We are on the record.
Okay, ready?
Yes.
Hello, my name is Denise Wells. I'm the chair of the Seattle Civil Service Commission, and I'm calling this meeting to order at 2:01. We're holding this meeting in a hybrid in-person and online format. The public can attend in person or watch online. This meeting is being recorded. For commissioners, staff, and others participating in the meeting, I ask that one person speak at a time. If you are participating remotely, please ensure that you mute yourself while others are speaking. Do we have any remote folks today? So, nope. The agenda is posted on the Civil Service Commission's website. We will proceed according to the agenda once it's approved, but first I will read the land acknowledgement of the City of Seattle Civil Service Commission, as well as introducing meeting attendees. We acknowledge that we are on the traditional land of the Duwamish people. We honor the land itself and pay our respects with gratitude to the Duwamish people, both past and present. Let us take a moment to reflect on the history of this land, the contributions of the Duwamish people, and the importance of reconciliation and respect for Indigenous communities. This acknowledgement aligns with CFC's commitment to its guiding principles and values of integrity, equity, and accessibility for all. I've already introduced myself. With the rest of the meeting attendees, please introduce themselves, starting with the commissioners.
I'm Steve Flynn, Commissioner.
Ray Caesar, Commissioner.
I'm Andrea Shealy. I'm the Executive Director.
Joe Van, one of the attorneys for the commission.
Sarah Butler, Operations and Policy Advisor.
And Teresa Jacobs, Executive Assistant.
Thank you. We have a quorum, so we'll proceed to the adoption of the meeting agenda. Is there a motion to adopt the agenda?
I'll make a motion.
Is there a second?
Second.
All in favor? Aye. The meeting has been adopted. Next is public comment. Teresa, was there any received any written public comment for today's meeting?
No, we did not.
Okay, thank you. And there's no one in person for public comment, so we'll move on to the next item, which is the approval of the minutes. I reviewed the minutes, and does anyone have any changes or comments?
I do not.
I do not.
Is there a motion to approve the minutes?
I move to approve the April 23rd, 2026 minutes.
And I'll second that.
All in favor?
Aye. The minutes from April 23rd, 2026 have been approved. The next item on the agenda are updates discussion.
All right. We do have a budget report. Thank you, Chair Wells. That is going to be on the green sheet at page 4 in your packet. This is a high-level overview of the department's allocated budget, also adopted budget, and spending throughout the year. We do have a small amount of money for encumbrances. I actually believe most of that, but we get connected in the system. And we are well on target for how far we are in the year for spending. So no unanticipated large expenditures yet this year. I think, my prediction, if I was a predicting betting kind of person, I'd say we're going to come in under our allocated budget this year. And as for budget process for 27-28, we have made our submissions to the budget office. We've received some guidance back, and we'll be working through that internal process as it goes, expecting that the mayor's budget will be published in September 2020, this year, 2026.
Just curious, as I just saw an article in the paper this morning about the big huge budget deficit for the next 3 years. Has there been any indication that your budget might change for next year? Well, it sounded like they weren't really trying to do many cuts to departments, but
We have been instructed to put a reduction in, but I prefer not to talk about it on the public record, but I'd be happy to check in with you after this meeting if you'd like to do that. There's also, I read in Publicola today, which is a local blog that I'm sure we're all aware of, that the mayor has got some ideas about different potential sources of revenue that would go to a vote of, well, first would go to the city council for a resolution, then a vote in November, I believe, to establish Seattle to establish a fire district in Seattle that would allow for some additional taxation tools.
Okay, right, thank you.
You're welcome. The department budget does include our work on that budget plan for 26 or 27-28 biennium. We're going to hear from Sarah Butler a little bit later on in the meeting in old and new business. Actually, I mean, well, let's do it in old and new business about rule updates, timeline coming up for you all. And we continue to develop and administer promotional and entry-level exams for the Seattle Police and Fire Department. Actually, today was the last day of the battalion chief oral, was the last day of the oral boards, which is actually a little bit of a misnomer because it was a written exam component today, but that gives our staff heading into a little bit of a break until the fall when they will be administering a fireboat exam, and development season kicks in right about now. So it's sort of our work cycle for the year on the public safety exam side. Just in case, departmental work, we also, this is a public safety civil service commission, but we did have a hearing scheduled to start in June, and that matter just got continued. So that will not be happening in June. And I'm ready to proceed unless I can answer any questions, but from commissioners on the case status report and appeal updates. All right, I'll proceed. Franklin v. Seattle Parks and Recreation, CSC case number 2607001A, is a appeal alleged violation of the personnel rules that you all delegated to the Office of County Examiner for hearing. And we did just get notified that there is a pre-hearing conference scheduled in that matter for May 27th. So thank you to the Office of Hearing Examiner for keeping us in the loop on that item. The second appeal. What, got a weird.
Sorry.
Oh, no problem. The second appeal, and I'll point you to the case status report because that's where this information lives. Pardon me. Is LaCombra. We actually had an appeal filed by Mr. LaCombra. Pardon me. Sorry about that. Now is the time my throat is tickly. We had an appeal filed by Mr. LaCombra that was 2604. Thank you. 009A. I reported to you last month that we did dismiss that appeal for lack of jurisdiction. Mr. LaCombra is not unemployed, does not have standing to file an appeal under those rules. Sorry. Sarah, would you mind picking up the update of LaCombra for me?
Sure. LaCombra then submitted a political patronage complaint. We've received an acknowledgement letters to both parties, and we are proceeding with an investigation as required by the CSC rules.
And you just can tell me what the process is after you guys on what you'll
Yeah,
a little more information about.
sure.
What that means.
Currently, we're gathering information from the parties as part of the investigation, and then we'll review it.
Then give a recommendation to us about how you can move forward, kind of like we did before.
Yeah.
Okay.
Thanks, Sarah.
Anything else for your update?
I missed the LaCombra update, but thanks for reading that. No, I'm gonna wear a mask. I don't think I'm sick, but boy, I'm gonna cough a lot. No, those are all the updates I have. Let's not forget to get Sarah Butler's update on the rulemaking.
Okay, we'll do that with after Joe. EMA training.
Okay, let's do the OPMA training. Let's see if it's gonna work this time. Go to share screen. of that, sorry. That's just, you can see that. Okay, here we go.
I'm gonna join from my office in case I like keep coughing. But I'll be just join remotely. Sorry, everybody.
Okay.
Making a scene of myself.
Let me put this in the full screen. It's gonna work. Yeah, I'm clicking on those. Okay. Think that's a better way to do this.
I think you have to be on that.
Yeah, see, what you're seeing is not what's happening on my screen. I'm clicking on,
Oh, what if you click on view up there?
yeah,
Oh, you
doing
can't click on
that.
that.
It's not doing, I click on things and it doesn't, nothing's happening, so I don't know what the truth is here.
Okay.
One more time here.
Well, I can see, okay.
Yeah, you can see it, but
I can see, okay.
Oh, but you can't change slides.
Can you bring me on screen? Teresa.
sorry about
I
that.
don't know
It's not
where this
before, I don't know why this is to sharing screen. It doesn't seem to work, so.
Mhm.
No, it's just got delayed, I guess, there it is. But that's not last time. But you got to work last time, so what you do? Yay! Sorry about that. I'm sorry what the situation is with this interface, but. Okay, so today we're going to do the OPMA, Open Public Meetings Act training. I'm going to refer to it as the OPMA just to abbreviate. So, and as a follow-up to today's session, I will email to you the PowerPoint presentation, as well as at the very end of this, I'm going to, separate than the OPMA, talk about this one pager that I've shown to somebody, I think, before. It's called Basics for Boards, related to our parliamentary procedure. So again, that's not directly related to the OPMA, but it's just something that we can go over. So I'll email those to you after this. And then the reason is when I put together the PowerPoint slides, I try to provide some detail in there so you have that as a resource, basically. So it's a good reference point to look back to, but always feel free to contact me with any questions you have. And of course, contact me before you do the thing so that I can help, avoid any issues. If you have any questions, feel free to contact me. Today, just to remind everybody, so we're in open session. I'm going to be talking about legal requirements, but this is not attorney-client privileged. But in the future, if you have legal questions that need legal advice, we could go into executive session, or you can contact me and we can talk about it that way. So this is not, as you're all aware of the OPMA and are quite versed in it, actually, all of you. But it's still important to have reminders related to some of these points. And what I always try to do too is bring to you some recent case law or otherwise to help let you know that it's not just academic. There are agencies in the state that don't follow it, get penalized for it. Okay, so I think that's it for the intro. Let's go. I want to start with this initial slide, which is just thank you all very much for your service. What you do for this commission is really, this commission is very important. What you do for the commission is very important. And this training is part of what you do in your role. Sometimes your job can be kind of thankless, and I appreciate that, and I really appreciate what you do. So thank you. Right, so in terms of the purpose of today's training, we can really boil it down into one sentence. Meetings of the City of Seattle's governing bodies, which include the Civil Service Commission, must be open to the public unless exceptions apply. So why are we doing this today? We're doing this because you are members of a governing body under the OPMA. There's other, you may know, there are about 70 or so boards and commissions in the City of Seattle. And if they're purely advisory, there's an argument that some of those are not subject to the OPMA, but the City of Seattle wants to always take the default of transparency. And so the City of Seattle treats those as subject to the OPMA, but the Civil Service Commission is definitely subject to the OPMA. This training, as such, it's mandatory under state law. And also refresher training is required at least once every 4 years. So because we really care about this, meeting legal requirements in this law, we try to do this training every year. And I try to change it up a little bit just because especially if I'm speaking to the same commission. And so we can talk about that for next year because hopefully you'll all be in the same office in 4 years, but who knows, right? And the other part of this is why it's important is what's laid out in the law itself. So let's go to that in the next slide. So I try to center this on going back to the origin of the OPMA, which is, it was enacted through initiative by the people of the state of Washington in 1971. And what was stated in the initiative, the legislatures captured that in the OPMA and state law under RCW 4230.010. And these are some bullet points that kind of emphasize what the legislature, what the people were thinking when it was adopted, which is important in terms of the legislative purpose of it. So in this case, let's talk about this commission. So all commissions and all other public agencies of the state exist to aid in the people's business. Their actions are to be taken openly, and their deliberations are to be conducted openly. The people of the state do not yield their sovereignty to the agencies which serve them. So, the people do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. People insist on remaining informed and informing the people's public servants of their views so that they may retain control over the instruments they have created. For these reasons, even when not required, public agencies are encouraged to incorporate and accept public comment during their decision-making process. And I will say my experience with this commission is currently constituted and previously all commissioners I've worked with on the Civil Service Commission as well as Public Safety Civil Service Commission take these obligations, these duties, these principles very seriously. And I really appreciate that. It's never going to be pushed back. Like, why do we have to do this? So I appreciate that because this is why it's important. You know, it's not like a nice to have. It's a requirement. Next slide, please. So in terms of what could happen if you don't comply with the OPMA, it's important to know that just kind of as a starting point, more from the 30,000 foot level. Just as a general matter, the violations of the OPMA, you may see articles in the newspaper from other agencies that violate the OPMA at times. It just leads to a loss, or can lead to a loss of public trust and trust in the city's commitment to transparency and open government. In my experience, the city does care a lot about transparency and open government. And so if the different governing bodies don't live up to that obligation, then it doesn't look good for it looks bad for the city as a whole. So it's bigger than just the Civil Service Commission. Also, it's a waste of your time not to take action and not follow the OPMA, because anything you adopt in a meeting that was unlawful is void. So it's not worth your time to do it that way. So in your case, it'd be more of an order or a motion that was passed, or some action you took when you voted on something that meeting was illegal, then it'd be void. Also, in terms of just you individually, they can serve as a basis to remove board commission members because you're expected to follow the law. So if you don't, you all are appointed to this position. So you can serve as if there was no violations by commission members, then those who appointed you would not be happy. And then also under the OPMA, and this is different than the Public Records Act. The OPMA, you can be potentially subject to individual liability, where if there's a knowing violation, that's why this training is important, so that you know what the law says, so you're not going to inadvertently violate it. But if you, if I advise you about doing something that you couldn't do and you did it anyway and violated the OPMA, that could be considered a knowing violation. And you individually could be subject to penalties. So $500 fine for the first violation and $1,000 for any subsequent violation. And also, if someone brought a legal action against the city saying that there was a violation and they prevailed, they would get the attorney fees and the costs related to that, their attorney fees and costs, which can be very large. The litigation is very expensive, so that's important. Slide, please. All right, so let's start with kind of the key concepts, and we'll run through this fairly quickly because again, I know that you all are pretty well versed in this. But a meeting that term is very important. It means meetings at which the governing body takes action. And then I always try to think about it. What does this really mean in English? So in practice, it means that a meeting is a gathering of a majority or more of you all, so 2 of you or more. And at that gathering, those who are participating in that gathering, the 2 of you, or 2 or 3 of you, you have the collective intent to transact the business of the commission. So that the collective intent that comes from case law in terms of how to determine whether or not. So say 2 of you went to a Mariners game and never talked about commission business, and you can do that, that's fine. But say you met at a coffee shop to talk about commission business for that purpose, and you intended that so you had the collective intent to meet to talk about commission business, and then you say brought that to a commission meeting in the future. That would be a problem. That'd be a violation.
So how about, just to be devil's advocate here, how about you met at a coffee shop just to meet at a coffee shop, and then as the course of that meeting, you happened to bring up commission business?
Yeah, so
that wasn't your intention for a meeting, but it happened as you were having coffee together.
Yeah, so I would hope what you would do is say we can't talk about commission business.
So I just want to be clear that even though it's not your intent originally, even if it comes up, it's still a violation.
Well, if you then say the person in your meeting is a commissioner starts talking about commission business, and you say, well, no, we can't talk about commission business, and then that person brings it up 5 minutes later and say, hey, let's talk about this. Say, okay, then it becomes what would happen in litigation, and I never want you to go down this road because it'd be a real pain for you all to be involved in litigation, because litigation is very time consuming, but there'd be depositions. They'd be asking you under oath questions like, okay, where'd you meet? What'd you talk about? Did you know there was a violation? Did you have training related to this? All that. So it's a little tricky for you all because there's only 3 of you. So if 2 of you communicate, it's not just by meeting, it can be through emails. We'll talk some more about that, of course, and other ways about commission business, then that could implicate the OPMA. So that's what I would hope you would do, say, no, we can't talk about commission business. There are some minor exceptions, which we'll talk about, but that's the rule.
Okay.
And I know you all take that very seriously. I know you're asking that to play devil's advocate, you would do that, but that's the way to handle it.
Great.
So then by extension, kind of the flip side of that is just in terms of thinking through this. So if there is the majority of you at a setting, at a gathering, and you have the collective intent to meet, then that's what's going to create that problem. So again, but that doesn't, what this also only relates to, in terms of the topic, we're talking about commission business. So as contrast, say, to the city council, because their scope of authority is related to all city business, or very broadly, right? But what you're dealing with is just commission business. So if you meet at a coffee shop and talk about city council that's not about commission business, that's fine. Or say you talk about what's happening just in politics or something otherwise, that's fine. It's about commission business. So I wouldn't, overread that to think, well, there's ways we can get around this. It's not about that. It's just to make, what this is about is transacting commission business. And we'll talk about the definition of action is very broad in the OPMA. So that's important to consider. Next slide, please. Okay, some further considerations. It can apply, as I mentioned, doesn't mean you have to be meeting in person. It can be through email, it can be by telephone, it can be through video conference. So it's having back and forth communications, however that happens. And then if the prereqs for a meeting are present, so a majority of you with the intent to conduct business, the gathering is a meeting under the OPMA regardless of how it's titled. So today we're in one of your regular meetings, which you establish through you vote on your schedule, the regular meeting schedule for the year. That's what this is. Anything else that's not on your regular schedule is scheduled as a special meeting, no matter what it's called. So it's called a workshop or a retreat, whatever it may be. Those are special meetings. Next slide, please. All right. So the key term is action, and as I mentioned, action is very broadly defined under the OPMA. So it means the transaction of the official business of the commission on behalf of the city. It includes, but it's not limited to, this is how it's stated in state law, receipt of public testimony, deliberations, discussions, considerations, reviews, evaluations, and final actions. So key point there is that, as you all know, it doesn't just mean final action. It doesn't just mean a vote. It also means considerations or discussions. That's why I keep referring back to that. If you're discussing commission business, then that, and you have the collective intent to conduct commission business, then that's a meeting. So the part of this, there could be situations in other contexts, like for the city council, for example, if they have different subgroups that are set up. It's not always the case that those subgroups are going to be subject to the OPMA. But for you all, there's no way you can have a subgroup because there's only 3 of you. All right, next slide. Okay, final action is a very important term, especially in recent years because the legislature revised the law, state law, to provide for additional requirements about public comment being required before you take final action. So final action, it means a collective positive or negative decision or an actual vote by a majority of the commission. In your case, it'd be by motion. That's the way you all operate. It can also occur via subcommittee, but that doesn't apply to you. So I just made that point about the city council. The other key principles here, secret ballots are prohibited. We'll talk about executive sessions in a bit, but that's, as an example, you don't have any votes in executive session. That's a secret ballot. Final action must occur publicly in open session. And as I mentioned, it has significance related to public comment. So next slide. So there's only 2 kind of meetings, as I mentioned. One is a regular meeting, and the other is a special meeting. It's the only kind of meetings that are defined or that are recognized under the Open Public Meetings Act. So the regular meetings are the ones that are on the recurring meetings you have on a monthly basis, and the way it's adopted through the commission adopts their regular meeting schedule for the year. You've done that, it's posted on the website, and those are your regular meetings. So you can deviate from that schedule, but it just means that any deviation is a special meeting. So I won't go through all the different requirements because Teresa is really good about all of this. The state law provides for certain notice requirements for the different kinds of meetings, and that we make sure that our work. Teresa is very good about making sure those are all compliant with for your meetings. So the agenda must be posted online. on the city website at least 24 hours in advance for a regular meeting. Key here, and we'll make this distinction with special meetings. So for a regular meeting, I know you've heard this from before, but it's important. Basically the agenda that's printed prior to the meeting is really a preliminary agenda, because that's part of why I encourage you all to consider and adopt your agenda at the meeting itself, because you can revise it. So say something came up that you really wanted to include on the agenda, you can revise your agenda at a regular meeting, and you can actually take action on it. So it's not the best practice to say vote on something at a regular meeting, even though you can if it hasn't been on the agenda prior, because the public wouldn't have known about it. So it kind of looks like you're trying to hide something. But there could be a certain emergency situations where you want to, or just time sensitive situations where you'd want to do that. And hopefully never for this commission, but just to know if you ever hear that you can't do that, you can do that. You can do that for regular meetings. I said that one of the bullet here is there's no restrictions on legally transacted business. That's what that means. That is legal to do that. And in terms of public comment, so the general notion is, or the general legal requirement is that, keep in mind, first of all, I won't get into this a little more, but public comment, it's your meeting. These meetings are your meetings. That's for the commission to do its business. So public comment is important to hear from the public, but it's not, for the most part, except in, which we'll talk about, it's not required under the OPMA in all circumstances, which may be surprising to some people, but it's not. There are circumstances it is required, but regardless of whether it's required, I recommend it because it's a way for the public to provide you with input and help you make good decisions. So, what the public does, they have the option, and it's identified on the website for the commission, to send emails to a certain email address that then Teresa will provide to the commissioners. And so they don't need to say this is public comment, they can, but it's also just a way for them to communicate with you, to provide you with input. So do on that front as well, do pay attention to your email accounts, your city email accounts, because that's the way that the public can provide you with public comment. And of course, people can come to your meetings too, and you allow for public comment on your agenda, and that's what that's for. So they can come to your meetings in person, and they can provide you public comment. Next slide. All right, so then the other kind of meetings are special meetings. And so as I described, these are any other meeting that's not a regular meeting. And there's a few things to think about related to those. So here's the kind of key exception under the OPMA related to when you can communicate. So a special meeting may be called either by the presiding officer, so by the chair, or by a majority of the members of the commission. So say in a worst case scenario, the two non-chair commissioners wanted to have a special meeting and the chair didn't, you could still do it. But the thing is, say the chair didn't show up for the meeting or something, but there'd still be a majority, there'd still be a quorum, so there'd still be a meeting. Just like if the chair wanted to have a special meeting and say, okay, we're gonna have a special meeting next Thursday, it's 2:00. And the other commissioners said, well, no. And so there wouldn't be a meeting if there's not a quorum. So, but that's, hopefully that would never happen. You'd only want to, as chair or as a majority, you'd only want to have a special meeting if you needed to. But this gives you a lot of flexibility to have meetings whenever you need to in these special meetings. So it's, and you can, the exception I'm talking about is you can communicate with each other and not violate the OPMA to communicate about whether to have a special meeting. So all three of you, this is the limited exception. So for example, the chair could communicate, you could send an email to the other two and say, I really think we should have a special meeting next Thursday. This is why. Are you available next Thursday at this time for this? You can communicate about that. And that's not a violation of the OPMA, even though you're communicating with all three of you. Because it would just be about holding a special meeting and what time and what would be on the agenda. It wouldn't be to discuss commission business otherwise.
And there's still a requirement to post the agenda for that special meeting 24 hours in advance.
Yes.
So conceivably, you wouldn't call a special meeting without at least 24 hours notice.
That's right, exactly, right. Next slide, please. Yeah, so on that front,
Oh, that was the next slide.
hold on, we anticipated that. So just like with, there's some similarities and differences here with the regular meeting. So just like with the regular meeting, you need to have the notice has to be posted at least 24 hours in advance. But what is really significant is I emphasize with the regular meeting how you could actually amend the agenda at the meeting to take action on, even if you amended, even on the item that you amended the agenda with. For a special meeting, you can't do that. So you could, for a special meeting, you could amend the agenda, but you couldn't take action on the item that wasn't on the agenda 24 hours in advance. Because the whole idea is, and this makes sense if you just think about it from a higher level, regular meetings, the idea through the OPMA is that public is aware of those meetings, it's on a recurring schedule, it's posted far in advance, for the year. So they're on notice you're going to have those meetings and that you may take action on whatever you want to bring up at that meeting. Whereas a special meeting, they wouldn't know about it otherwise. They're special. They're set up, on an ad hoc basis. So if you don't provide the public with notice on what's going to be on the agenda that you're going to take action on, then that's not fair to the public. So, but I haven't had a situation with either commission here since I've been here where the commission decided to amend an agenda for a special meeting and want to take action on that. So that distinction I'm making there is important. So you can amend your agenda for a special meeting at the meeting, but if whatever you amend it with, that you can't take action on that particular item. Does that make sense? Okay. So actually, let me clarify that. Let me state that more in a better way, because it's not take action on it. So you can't take final disposition on it. So you can't vote on it. Because remember the word, let me just correct that, because as I said, the word action is very broadly defined. So you can discuss that item, but you can't take final disposition on it. So you couldn't vote on it at that special meeting.
But you could agree to put it on the next agenda of the regular meeting.
Yes.
Okay.
Yes.
And would that be an action? Would you have to vote on that to put it on the next agenda?
Well, you can just say, for example, as a chair, you could say, okay, based on today's discussion,
Okay.
I intend to put this on the agenda for the next meeting.
Okay. You wouldn't necessarily have to take it. You wouldn't necessarily have to all agree to that.
Yeah. And, again, because you all have had this training before, this is a little more in the weeds, but I'm doing this to make this training into further depth than maybe you've had before, because this is a concept that I may have in the past kind of gone over quickly, but it's important to know the difference there. So again, I'm not encouraging you to add anything so once the 24-hour notice has gone out for the special meeting, I'm not encouraging you to add anything to that agenda within that 24-hour period. But if you did, you could, but you just couldn't vote on it at that meeting. All right, so this calls another topic that's really important, which we've already touched on, but it's called rolling or serial meetings. These are kind of situations that can arise if you're not tracking this carefully and being cognizant of this. So such an act, this would be if this a rolling or serial meeting would be an unlawful meeting, and it can occur if action is taken by a majority of the commission, and even in situations where you're not in the same place at the same time, for example, through email. So a key consideration is whether the members at issue had a collective intent to transact the commission's business, as we've already talked about. Communication exchanges between the commission or so social media can also implicate this, so keep that in mind as well. And then passive receipt of information is acceptable. I'll talk about that. So this is important because just because of social media. So even if two of you are involved in some kind of back and forth exchange of communications about commission business, whatever the forum, then that could constitute a meeting. So don't engage with your fellow commissioners. It's easy enough to think about it if you're physically in person with each other at a coffee shop or something, but also through email or through posts on whatever it may be, any social media platform. Okay, that makes sense?
Mhm.
Okay, Next slide, please. But so another, well, I always like to think about what you can do to get your work done that complies with the OPMA instead of just talking about what you can't do. So in situations, for example, where you have drafts that you're working on, say we're working on rules, and you're looking at different drafts of rules, and you have different proposals for, say you get a draft of a rule provision for the commission to consider, and maybe you have proposed amendments for that, or you want to work with your other commissioners going in prior to the next meeting so that you don't have to just bring this up at the meeting, that you give your fellow commissioners time to look at it. You can send an email to your fellow commissioners, but put on the top, for informational purposes only, do not reply, just to make sure that the other commissioners know not to reply to you. But so it's just a one-way communication. You send them an email saying, here's the proposed amendment that I have for our next meeting. Please consider it before the next meeting. And then when you're in the meeting, it just makes your meeting much more effective and efficient because you've already considered it. You can talk about it. Or say there's an article that you think is really important for the other commissioners to read. You can send it. Same thing. Put for informational purposes only, do not reply, and send it to them and say, I'd really like you all to consider this article prior to the next meeting because I want to talk about it at the next meeting. Something like that. Another way you can do that is you could send those kind of communications through Teresa or through Andrea's staff members because they're not part of the commission, and then they can provide it to the commission. As long as that, say if it was Teresa, as long as there's not a communication that then combines to a majority of you in the communication. So again, this is about one-way informational only type communications. Right, so next slide. Some other practice tips in this regard. So the reference to passive receipt of information. So that's good terminology to always keep in your mind because that's something that Washington courts have talked about. So again, that's what it means. It means a one-way communication. And as the receiver of the information, you're passively receiving it. You're not exchanging information. You're not going back and forth. So passive receipt of information is permissible, but work from the presumption that discussion of commission business via email by a majority of the commission would constitute a meeting. One-way email to majority of your colleagues on the commission is allowable when the message is to provide, for example, only documents or factual information, such as emailing a document to all members for their review prior to the meeting. And again, just to make it clear for your commissioners, you see there are times when I send you attorney-client privilege often, or sometimes other emails, and I always put this on there for informational purpose only, do not reply or do not include other commissioners, just to give you a heads up that not to do that, just as a reminder. Next slide, please. All right, a few other practice tips. Actually, so I've already covered all of this. We just talked about it. So next slide. Okay, next topic. So in terms of meeting formats, it's important to think through some of this so that you know about it if questions get asked or you're thinking through how we do things in practice. So absent an emergency in-person attendance from the public must be an option. So that's why you have, even though you can, as commissioners, based on your bylaws, your rules, you can participate remotely if you need to. But even so, even if all three of you were participating remotely, we would still need to have a physical space, which for the public to come to watch your meeting, basically. And it's also, if there is going to be remote attendance by any commissioner, there's two-way communication so that you're not just watching, you're able to communicate. And it's to reiterate that point, just that remote attendance it's in addition to, it's not to replace in-person attendance. So again, this is more about the public being able to participate in your meetings to the extent that they can watch you in real time what you're doing. And it's also under the OPMA, it states that the attendance, so if remote attendance is allowed, It should be free and offer real-time observation and participation. So, and that we comply with all of this. So it's, for example, you could charge them to through some website or something to participate in your meeting. Next slide. And again, when I say participate, I'm not, we'll talk about public comments some more, but participate in this context means for the public to be able to watch your meetings in real time. So public attendance at meetings, you can't require the public to register their names or any kind of barriers to entry in terms of participating. So for example, when you allow for public comment, you'll see this with the city council. They'll keep lists. They'll have so many people that like public comment. So they'll have lists of names, but someone, for example, can give a different name because the council is only doing that because they want to be fair about having people sign up, give them time. And if that ever happened here, say we had 20 people in here and you wanted to have them sign up so you could go through your list to make sure everyone has time to speak. But if they didn't want to provide their name, you couldn't require that, or especially their address or any other personal information. I mean, you could ask for it, but you couldn't require it. Because again, there are some people they may want to keep their identity to some extent private, and they don't have to provide that in that format in a public meeting. However, in terms of just conducting your meeting and keeping order, you can have what you do have through your rules. You can have reasonably stated requirements related to how the meeting is conducted. So, for example, during COVID, this had to do with having a meeting in a way that protects public health and safety. Hopefully, we won't have another pandemic, so don't have to worry about that. But also conducting the meeting so that there's not disruptions. No one's not allowing you to do your business. So you have reasonable rules from the public participation standpoint so that it's not disrupting your meeting. But that's a kind of a high bar in terms of you wouldn't want to. It's about people physically doing something that doesn't allow you to do your business, basically. Next slide. All right, just a few more here. So I've touched on this, but public comment, it's as a general matter, it's not required, but it is required for regular meetings, so not special meetings, regular meetings, in which final action is taken. So in the simplest form, it would be a regular meeting at which you're going to vote on something. Say vote on UD. Then it's required. But in other circumstances, it's not required. But again, I recommend it that you do anyway at other meetings because again, it's just a good way for you to hear from the public. I have the next slide just for your future reference. It's kind of a decision tree to have you see what the state law requires related to this. But that's the basic notion of the clear notion. Also, the commission is authorized to deal with interruptions, I mentioned, and it's not required to accept public comment that renders orderly conduct of the meeting unfeasible. That's kind of language from the OPMA about that. Unfortunately, you don't have issues related to that for the most part. But again, that's just to emphasize that these meetings are your meetings, and the public has a right to participate in terms of watching you in real time, but not to be here to disrupt and allow you to do your business. Expected. You go that. So this is that decision tree I was talking about for future reference if you ever want to look at it in terms of when public comment would be required. Next slide. Okay, so it's next topic. Just a few more here. So let's talk about executive sessions, and this commission does have executive sessions, and also I'm going to make a distinction between executive sessions and closed sessions because they're different. And this commission, you do have situations where either one could apply. Some boards and commissions, for example, they never would have a closed session. There's no basis to have one, but this commission would potentially. Okay, so executive sessions, they're not open to the public. They're confidential. So you can only have an executive session based on what's in state law. It's under 4230-110. It'll list the specific topics, the only topics that you can discuss in executive session. And the one that we use primarily relates to to get legal advice from your legal counsel to discuss potential agency action. And in that situation, the legal counsel has to be there because you're getting legal advice from legal counsel. That's the whole purpose of the executive session. But there could be situations, it's like for example, some city councils, not our city council, but where there could be a topic like, say, maybe it's an employment matter. There could be situations where you talk about employment matters to some extent. You could in executive session where it's not a legal requirement that the attorney be there, but as you all know, in our case, it's a good practice because there's always going to be there's often legal considerations you discuss as well. So you want the attorney there. But the point is, if it's an executive session, whether or not it's attorney-client privileged or not, it's still confidential. So whatever you talk about in the executive session, you cannot share with the public. You cannot share with anyone who was not in the executive session. Okay, and I already talked about there's a distinction with closed sessions. We'll talk about that some more. Next slide, please. All right. So what has to happen for an executive session, because executive sessions happen as they have to be part of a meeting of under the OPMA, so they have to be part of a regular or special meeting.
And what happens in those executive sessions? It's not recorded either.
Well, so or
if it's recorded, it's redacted from public disclosure. How does that work?
Yeah, it's not recorded. So the way those are good questions. And this process is important. And in fact, you may have seen in the paper yesterday at Seattle Times, there was an article about the Public Disclosure Commission, and there was a lawsuit brought by a person who was successful, got a settlement from the Public Disclosure Commission for $25,000 because allegedly that commission violated the OPMA by having executive sessions that they didn't follow this process. So that's why it's important that we follow this process, which is when you go in, that's why I'll provide the presiding officer with a script to say when you go to exec session. So you're saying, we're going into exec session now, this is the purpose of the executive session. So it's to say, and that's based on what's in the OPMA related to those purposes. So it's either to discuss with legal counsel, to get legal advice, or, for example, it'd be either for your commission, it's either going to be that usually, or to discuss, say, different employment matters. But we always state that on the record before you go into exec session. And then the OPMA says that you need to then say how long you're going to be in executive session, because again, it's all about the public. So the public can't be a part of your executive session. So you're announcing to them, we're going to be in executive session. You say about the time, say for 10 minutes. And so the idea is there, if they would say they're watching your meeting, they can leave for 10 minutes and come back, and they're not going to miss anything. So that's why it's important. Always underestimate the time. You can always extend. You can always say, it's going to be 10 minutes, and then you get an exec session that's taking longer, then you can come back out and say, okay, we're extending it. You can have in this case, Teresa or the presiding officer can come back in open session and say, we need to extend this exec session for 10 more minutes or whatever it may be. You can do that. But say you said, we're going to be exec session for 30 minutes. You came back after 10, you have to wait that 20 minutes to start your meeting again, because again, it's not fair to the public. And you're starting your meeting before you said you would, and then they wouldn't know if they left the meeting and came back, they would miss out. So that's why I always recommend that you underestimate within reason and you can extend. But that has to be announced on the record. So as the presiding officer, you announce it in the record or on the record that you're going to exec session, why you're going to exec session. You go in, we have that discussion during the executive session. Some of this is covered in upcoming slides, so we'll skip through some of those. But when you're in executive session, it's confidential. It's not recorded, so there's no audio or video recording of it because it is confidential. There's no minutes kept of it. So the only thing that's reflected in the minutes of the meeting is you had an executive session about that topic, that's the general topic, which was the purpose of the executive session. But there's no minutes kept of the executive session.
Okay.
And because it's confidential.
Right. So conceivably, Teresa wouldn't even be in there.
And she's not.
Right.
Yeah. And that's an important point, is that you would only have people in the executive session that need to be in the executive session.
So yeah, attorneys or commissions, or
right.
If there was an employee that needed to be there to provide context for the discussion, right. Or something like that.
Right. Okay. Right. And we I see this more in terms of other types of legislative bodies like city councils where they say there's consultants, there's experts that are talking about a particular issue. But even in that case, the caution would be the more people you have in the executive session, the more the chances that someone's going to breach that confidentiality. Because sometimes it's some people may not remember exactly what they're talking about this exec session or did I talk about it someplace else. So that's why we just keep it pretty limited for good reason. All right, so that's exec session. And then there's a whole other concept which are called closed sessions. And again, most boards and commissions in the city, this does not apply to, but it applies to you all because when you have hearings, when you have quasi-judicial matters. So those are situations where there's appeals. So when civil service members, there's a disciplinary action against them and they make appeals. So like on today's agenda, there was a couple different matters that are on your agenda. So if those become situations where there are hearings on those proceedings are called quasi-judicial proceedings, which that just means that you're acting somewhere as a court in those situations. That's why they're quasi-judicial. And they're closed sessions. And under the OPMA says that closed sessions, the OPMA does not apply to them. So they're outside the OPMA, which means you don't need to comply at all with the OPMA related to those sessions. So for example, during a hearing, you have an open hearing. That's the process, but your deliberations related to that matter would be in a closed session. And so in that the OPMA doesn't apply to that session. And then, so for example, just like a court, if you think about it like a panel of an appellate court, they hear from the parties and then they go into their chambers and then they discuss and actually make a decision. And they come out in open session and say, here's our decision. But all of this deliberation happens in closed session. They don't generally have that discussion open session, right? So it's a similar concept. So that's the main way that closed session would apply to this body. Unfortunately, you don't have that very often, but it is important to remember that distinction. Next. All right. So to reiterate this, just so you know more broadly. So again, for this commission, the way this would come up would be through quasi-judicial matters hearings and appeals. But just so you know, like for the city council, another basis for this would be collective bargaining sessions, labor issues. So they can do that in the closed session, which the OPMA doesn't apply to that. Okay, next slide, please. All right, in terms of minutes, this came up previously. So the minutes of the OPMA provides the minutes of your meetings have to be promptly recorded and open to public inspection. That doesn't mean that they're recorded there means that you have some kind of written document that has the minutes for the meeting. And that's what Teresa does, and she does a great job of it. And what I recommend, which Teresa does, is that the minutes aren't meant to be a transcript of your meetings, as you know. They're meant to summarize what happened at the meeting. Most importantly, what action was taken at the meeting. So basically, you have your agenda that lays out the items. The minutes basically go in the same format and just say, okay, for this item on the agenda, this is what happened. And if there was a vote, it'll say what the vote was. That's a really good format that Teresa follows because you don't have to reinvent the wheel. It's already there. You already have the agenda. So it's for the public to know what action was taken. I have seen situations where even in our city, there are some boards and commissions that have some pretty detailed minutes, but unfortunately, what I've seen can happen is if you try to describe what people said, especially members of the public, then oftentimes people say, well, no, that's what I said, they did say that. Or, I also said this, why didn't you include that? So again, that's not the purpose of the minutes. If you're in as we just talked about, if you're in a hearing related to an appeal, there's going to be a transcript. So that's a whole different situation. But that's not what minutes are set up for. They're not set up to be transcripts. As we talked about for executive sessions, minutes are not only not required, we don't do them for the reason we talked about. But as we talked about, the purpose of each executive session must be recorded in the minutes of your meetings, which we do. That's why, again, it's helpful for the chair, as we do, to announce the purpose when you go into exec session, and Tracy can just pick that up in terms of the minutes and put that in there. Okay, state law is quite flexible. It doesn't say you have to do minutes in a certain way, but these, as I described, there are action minutes is a really good format. That's what we do, and so and that works really well. And it's fair to the public too, because they know what happened during the meeting. But the reason I kind of drilled them into that a little further is just so if anyone ever from the public ever criticized you and say, hey, these minutes doesn't summarize what I said. I came to the meeting as a member of the public and I said a lot of important things, and you doesn't say any of that. Well, there's a recording of the meeting. Anyone can see the recording. And that's not the purpose of the minutes. So if anyone ever says that, then you can think about it that way. Next slide. All right, so last slide. For today, the 5 key takeaways I want you to leave with, in summary, is that this first point is really to kind of restate what's stated there, is that the OPMA is not set up to be the most efficient way for you to do business, and sometimes these rules and requirements can be a pain. Especially with only 3 members. Like, you can't communicate with each other about commission business outside of a meeting. That's not very efficient. But hopefully through today, you realize there are ways you can communicate, one-way communication, in an effective way. But the purpose of the OPMA is not for efficiency, it's for transparency and openness. So that's what the purpose is. So that's why I do that. I never had it with any of you all, but say at times where people come in fresh into government and say, well, this is ridiculous. Why do we have to follow this? It's like, well, that's why. Because it's, again, going back to where we started, this was adopted through an initiative of the people for openness and transparency, and for the people to say, you commission, you don't decide, what you can keep from us and what you can't, because you're serving us. That's the important concept there. All right, this training is not only important for us to talk through all this, but it's also a legal requirement. So congratulations, you've met that legal requirement, and Teresa keeps track of all this. So if there are situations where if there is litigation related to OPMA violations, that claimants will make allegations that this requirement wasn't met. They didn't have proper training, or say, and courts will look to that because it is a legal requirement. And most importantly, it's not so you check a box, but you understand what the OPMA requires so that you comply with it. And then you ask any questions that you feel like, if anything is unclear. As we talked about, it's really important to know the difference between a regular and special meeting. Also, to be aware of the concept of a rolling or serial meeting, especially today, because this goes into about 0.5, that there's so much changing technology that it's just keep those key principles in mind, that if you cannot have discussion about commission business with another commissioner outside of the meeting. But again, there are ways you can prepare each other for meetings by having the one-way communications. All right, any questions?
Yes, I have one.
Okay.
Joe, you mentioned there's 2 types of boards. There's the advisory board, and the other one is?
Yeah, so there's not really 2 kinds of boards. Just to be clear, under court decisions that have interpreted when a subgroup of a governing body is gathering in a way that would implicate the OPMA. So let me give you an example from a case that made this clear. So there was a case from San Juan County, and San Juan County had a county council, and strangely, their council only 6 members. So usually you have usually you have a governing body, you have odd numbers, but theirs only has 6. And usually county councils, but theirs was county commissions, but theirs was called county council, but that's their governing body. So in the case that made this clear, in that situation, there were 3 members of that council that were served on this critical areas ordinance task force. They set up this subgroup to think through the political areas ordinance, which is a very significant issue for that county, obviously, and for that council. And they kind of did it more ad hoc though, and they had other members from other experts that were involved in that subgroup. So it wasn't just those 3 members. So the issue was, okay, well, there's 3 of them. So, and then they talked about important council business. So didn't that violate the OPMA when they met? Because that group met several times. And the Washington Supreme Court said and this was all about, this shows you too, this is the Washington Supreme Court. So it went through a trial court, then it went to the Court of Appeals, and then it went to the Washington Supreme Court. So just many years of litigation. And the litigation, the court looked very carefully at all the facts through depositions and all testimony. So, but in that case, based on the facts as they were, there wasn't evidence that first of all, there's only 3 commissioners, so that wasn't a majority. So because there was a majority, then it didn't implicate that part of it. And the OPMA also talks about if you set up a subgroup, it can be a sub-agency, or there could be times when that subgroup would still be subject to the OPMA. But what the court held is in that certain circumstance, because what happened, what that group did is they were purely advisory. That's where I got that term. Mm-hmm. They advised the rest of the council about what they talked about, but they didn't make any decisions. And the council didn't delegate to them any decision-making authority. It was just, they were just getting input from the public and from other experts, and then they bring that to the whole commission at meetings. So that's the key distinction. That was really important. It was a really good decision to help all of us try to understand this. Then in that circumstance, that's why this whole thing about collective intent to transact the business of, in your case, the commission. In that case, they didn't have the collective intent to do the council's business. They were just advising the council about, this particular topic, and then the council itself would discuss an open session over several meetings, and then they took notes on different things. So in that case, from that perspective, there are boards and commissions for the city Seattle and all cities that do act in a way that's purely advisory, so that wouldn't be subject to the OPMA strictly. But again, the city of Seattle says we don't want to make those distinctions. So, and we really care about openness. So the city of Seattle says that we're going to have all our boards and commissions comply with the OPMA, even if they're not required to. So, but for this commission, there's no doubt. I mean, all of you are subject to the OPMA because you are a governing body of the OPMA. Yeah. But that's why that distinction is made, because there's other nuances that could make it really. Only going here because you raised this and because you all have good knowledge about the OPMA. But say, for example, a city council. Say there's our council has 9 members. So say you had 3 of them that were a subgroup that were reading about a particular topic. It wouldn't be a meeting of under the OPMA unless like the council had delegated to them authority to make some kind of decision, had some decision-making authority, also making authority, or this is a nuance that's in the public or the OPMA where it says if they have a public hearing at a meeting, so that subgroup had a public hearing at one of their meetings, then that meeting would be subject to the OPMA. So it gets to be, there's some nuances there, but again, for your purposes, all of your meetings are subject to the OPMA, and even those even boards and commissions that the city of Seattle has that aren't strictly required to comply with the OPMA, the city still, out of the interest of transparency and openness, has all of our boards and commissions operate under the assumption or just operate consistent with the OPMA.
Thank you for the clarification. I have one more question regarding executive session. While in executive session, I think I heard you say that if the 3 of us are in executive session and we want a consensus on a certain matter before we go back into the meeting, I thought I heard you say that you can't have voting or you can't have.
That's right. Yeah,
that would be considered a vote trying to reach consensus on what to bring to
Yeah, so you can discuss. The purpose of an executive session is to discuss. So, but you can't take action on something in terms of some kind of vote on something or saying, okay, do we have consensus? It's more, but you can discuss. So say it's a matter of then you go into open session and take action on the item.
Right.
Yeah. So in that discussion, it could be that everyone clearly states their opinion about a topic. So you can get a sense from that where people are coming from and whether or not people agree with you or not. But you're not voting, you're not saying, and that's really important. I'm glad you said that because you would never want to say, okay, do we have consensus? Or do we all agree? Because as a general matter, that would be something that could feel like a secret ballot. But it's more like this is what I think about this. Another person, this is what I think about this. And then if it's something that relates to taking action open session, then you go into open session and then you would, to the extent you wanted to, because again, the executive session is confidential, but in open session, you could state what you wanted to for the record, and then you would vote on whatever that matter is. If, a lot of the discussions we have in executive session, there's not a vote. There's not a vote in open session about it because you're getting legal advice from me about something. So it's more about me describing what the legal situation is that we're talking about, and then you asking questions about it, and that's the discussion. So that's an important thought too. Is think about executive sessions in terms of discussions. They're meant to be discussions because that's what if you look at the OPMA and the 423110, it talks about to discuss. That word discuss is used a lot because that's what it's about. It's not about reaching consensus or any kind of vote. That's all that. Thank you for the question.
I think what I think is challenging with only having 3 people, from what I understand, if we're in a situation like with rulemaking, or say we're drafting a letter, we have some kind of letter, we can't work on it together as a group beforehand, which is kind of challenging.
It is.
That you can't do that with drafts because you don't want to sit around a meeting and wordsmith.
Well, we're gonna get a little summary right here in a few minutes about some rulemaking, so maybe Sarah can give you some insight, or I can give you some insight on how we handle that. We do it a lot with public safety. We've done it frequently with the Public Safety Civil Service Commission, so hopefully we have a pretty good familiarity with it.
But it's a really good question because it just helps you be there are ways to do this and be efficient, totally in compliance with the OPMA, which is, so again, say it's a rule that's one paragraph that staff comes to you and says, okay, we want to make these changes to this. This is what we're recommending. Then what you all can do is you can either individually work with Andrea and say, okay, I like this, I don't like this, and work with her in terms of maybe crafting some different language individually.
Right.
Or each member of the commission could, on an information only basis, provided the commissioners, okay, here's that one paragraph, here's what staff's recommending, here's the instruct changes. You could say, okay, here's what I recommend. Let's talk about the next meeting. So with having only 3 of you, then that's important because for example, if like the city council, they could have like a subgroup that could work on a draft and then bring it to the whole council and say, okay, this is what we recommend. You can't do that. You can't have 2 of you.
I know, that's kind of interesting.
Yeah. But that said, it still will save a lot of time when you get into those situations where you provide each other with your suggestions before the meeting, not like, right before, but with advance notice, so that when you're in the meeting, then as a chair, you lead that discussion, you say, okay, well, we received, all of us received each other's comments and suggestions, and here's how I see, it looks like these comments are very similar, so here's what I recommend. Or even before the meeting, you as chair you wouldn't communicate with the others, but you could create a new draft yourself.
Mm-hmm.
And you could say, okay, I thought about this, and just in the interest of time, I created a new draft. Again, not to share with everybody before the meeting, but in that meeting itself, and say, okay, here's what I think this captures what you all are suggesting. and then you can talk about.
Which I think is fine, but for more complex documents, it can be kind of hard to be doing that on the fly in a meeting.
Yeah, it is. And that's why it's good, for efficiency's sake, if the whole commission agrees to this, maybe one of you can take the lead on those kinds of things and work directly with staff. And then in the meeting, when this comes up for the commission to consider, you can say, you know, these are the recommended changes. This is why we're recommending this. So it's not just about staff presenting it to you, but there's commission ownership over that process. And then the commissioners may disagree and say, okay, well, that's great, but I think we should have these words here or this or that. And then it could be that it takes a few meetings. That's okay. That's okay.
So I have a question. Since now with technology and being able to do live updates in, say, SharePoint, if we share a document with the commissioners, as long as can they make comments in the comment box, as long as they're not communicating back and forth?
Well, not if they're all accessing at the same time.
Or even like asynchronously, I think we want to avoid against access to the same document.
Yeah, you wouldn't want, so if there's, just like commissioner sending an email to another, so in this case, you know, the commissioner cannot send an email to another commissioner about commission business outside of their meeting. So the same concept would apply where if there's a draft document and say there's a draft and Denise has made comments in the margin and that goes to Ray and he's made comments, no, because that would do the same thing.
Such a good question though.
But flowing it through staff, isn't that a little bit, I mean,
well,
if I had my changes and I sent it to Andrea, then she incorporated and made her changes, and then she sent it on to another commissioner.
Well, so what I recommend is because it gets to be a situation just that can raise issues from the public thinking you're just trying to skirt the law.
Right.
So just keep it simple.
Right.
And so again, you could provide your comments to Andrea, and Andrea then could come to the next. What I recommend you wouldn't have this. You'd come to the next meeting and say, okay, I took all the comments that I received, and in the meeting itself, you could say, here's that draft.
Can I talk a little bit about the way that we do it?
Yes,
Maybe that will answer some of your questions. Okay, so Sarah, let's talk about this together. Maybe we can move on to our last point, which is the old and new business, where we're going to talk about the CSC rule updates. I'll let you kick this off though.
Sure, okay. So we have our.
But before we do that, I just want to make sure, Joe, are you done with the presentation for the?
Yeah, this will give a good segue into. Well, let's talk. The other thing is the boards and basics for boards. I'll just pass that out real quick. This. So, have you all seen this before? Steve, you have not probably?
Not here.
Yeah.
I've been up to it.
Yeah, so this is just something, I talked to you all about this, or talked to two of you about this in our past training, but what we did in the city attorney's office, in our government affairs section, is try to focus on just the most important things for boards and commissions in terms of parliamentary procedure, because it can get so detailed that it's not very useful. So just to kind of boil it down into a one pager. So this is a resource for you. It's most important for the presiding officer to be aware of this, and Denise and I have talked about this, and Ray, you and I talked about it previously. But keep in mind, the presiding officer has a really important role, but the presiding officer serves the commission. So that it's important for all of you to be aware of this as well. So the main point is that when you take action, and as you are doing very well, when you're going to vote on something, have the motion be clearly stated, and then you need to have a second. If it doesn't get a second, then it doesn't go anywhere, it just dies. And it could happen where you don't get a second. That's a reality, because you operate in terms of taking action on those final disposition on anything. You do it by majority vote. So if you get a second, then you ask for discussion, then you have a discussion. And then once that discussion is over, then you say, okay, do I need to restate the motion or something? Just to make sure everyone knows what the motion is. And then all those in favor? And if everyone votes in favor, then you don't need to ask for anything else because everyone's already in favor. But if not everyone's in favor, then anyone opposed, and then any abstentions. If again, you only ask for abstentions if someone didn't vote. And the only other nuance there is if someone offers, say you have the motion, get a second, have discussion. During the discussion, someone offers an amendment, they can certainly do that. So then you want to take up the amendment first. So is there a second to the amendment? If there's not, it dies. If there is, then you talk about the amendment, and then you have a vote on the amendment. And if the amendment then amends the initial motion, and so then in that circumstance, it's particularly important to restate the initial motion so that everyone knows when they finally act, when you all finally act, that you know what you're voting for. So what you can do as a chair, and this is just there's different ways to do this, but just for efficiency's sake, as the chair, what you can do is, because often the chair is more directly involved with working with Andrea and otherwise to prepare for meetings and working on the agenda, so may have more knowledge about some of the items on the agenda. So you could say, is there a motion to do something? So is there a motion to approve the minutes? What one of the other commissioners can do can say, so moved, instead of having to restate the motion. See what I'm saying? So she says, Denise says, is there a motion to adopt the minutes? One of you two say, so moved. And then is there a second? One of you seconds it, and then you vote on it. So that's just one way to speed it up so that she doesn't have to say is there a motion to do something? And then someone else says, okay, I move to do that. If you agree with that motion. Does all make sense?
Great.
And that's, again, the main point here is that the chair, presiding officer has a really important role, especially in terms of when you're speaking, you're generally going to, the presiding officer is going to recognize you to speak. That's just out of fairness for everybody. And the general notion there is when you're having a debate about something, that each of you gets to speak at least once before someone else gets to speak more than once. And you allow that discussion to carry on. You all get along really well. So, this is more, really matters more when it matters, when there's more, if there's a contentious situation. But this is a way to avoid those contentious situations by having the chair manage those discussions. And the main point, as I've mentioned to you before, is that it's not, parliamentary procedure. There's certain tricks of the trade, and rules of the road, but you don't have to be perfect. Just be yourself and just follow those basic principles. And if say for example, sometime if the chair slips away from that a bit, instead of saying, just does things in a way that doesn't match that I just talked about, one of the other members can say, or say you have a discussion and so there's a motion, there's a second, and then you have a discussion, you say, okay, let's move on to the next item. You say, no, excuse me, Chair, we didn't vote on that. Or I've seen that happen before. It's going, okay, there's this discussion, then the chair just moves to the next item on the agenda. It's like, no, we didn't have the vote yet. So, and I'd prefer that you all kind of work with each other on these matters. I'll jump in as I need to, but if you all work together, you all know these basic rules, and you can all govern each other because it's your commission.
Great.
Okay, thank you all. And then I think this other discussion, we could talk some more about how the working on drafts can relate to the OPMA also.
All right, civil service rules of practice and procedure. This is policy that's adopted to apply what is authorized by the code in terms of how the Civil Service Commission conducts its business, the roles and responsibilities. There's some procedures even that are listed in the municipal code, but this is the document that translates that and puts it into practice sort of on a day-to-day basis. So I'm not sure if you all have this, but I'll just go over it briefly. It talks about administration, and then kind of the two main business that's conducted here. on meetings is political proceedings as well as public procedures that are interested in that. So those are our rules. They were last revised in 2014, which is a long time ago. I am ramping up to go through a revision later this year, and I'll just sort of talk about what that looks like really briefly. This week, Andrea and I meeting internally to talk about scope of a rules change. Once we've got that decided, I'll need some time to put together a draft and sort of circulate it internally to make sure it meets our needs. After that, I start some outreach to our stakeholders, and that will be unions and departments. And remember that this has been 14 years, 12 years since I've done a rulemaking process. So, and there are many departments and there are many unions that we work with. So we're all going to kind of get into our groove of how this process works. But once I've done some outreach and received some feedback from them, it does go into a more formal notice that's required under Seattle Municipal Code. And that is 14 days prior to this being considered in front of the commission. It does need to be noticed in the Seattle Daily Journal of Commerce. It's a very broad notice. It points to a website. It says when we may consider a rules change. Then I post the changes online. We send out via gov delivery and any other emails to other stakeholders that we need to at that time. And then there is the meeting at which this is heard at is kind of doubles as what I think is referred to as a hearing in the municipal code. And at that point, the recommendations go in front of the commission for consideration to adopt and take action.
And so what would be really helpful for us, because we were talking about the drafting, we were talking about executive and other kinds of non-public sessions and the difficulty that you all create a quorum with just the two of you. It would be really helpful for us to identify one commissioner who would want to be maybe the sponsor for this rulemaking. And some things that would be helpful in figuring out which commissioner wants to do it is someone who has some time to interact with staff, someone who has an interest in doing it, someone who has maybe experience with either the civil service rules or other administrative roles in the city of Seattle, and Seattle's HR systems, which all three of you do have that. But the way it would look like in a practical sense is Sarah's working on this draft. Sarah's our policy and operations advisor. So she's really experienced. She's sort of, she's pretty well known in the city. Maybe you know her this way as being like an expert on the personnel rules and very familiar with a lot of the city's collective bargaining agreements and done a lot of that policy work. And we're lucky to have her here with us today. So we would come up with what we think is the best draft. We would also be soliciting, big ideas from the union. And I don't mean big changes. I mean, things that they have noticed to be pinch points with the civil service rules. I'm guessing that even though there's a lot of stakeholders here internally in the city, I'm guessing we're not going to get a lot of feedback from them because I don't think a lot of the unions or even the departments have had a ton of interaction. But we will get some. Anyway, so we would incorporate that as we would have conversations with stakeholders, incorporate that as we think is appropriate and helpful to the commission, helpful to the employees. We set our employees primarily in the reading of this because they're, the main audience for them. And sort of, we have a lot of HR professionals in the city, but, sort of that's the level we want to be writing at. So it's readable and usable to hopefully every employee. We're probably going to have most employees. And then in terms of drafts, once we got a draft sponsoring this, we would circulate a draft. I don't know whether we do SharePoint or just email, whatever's easiest for those commissioners, circulate a draft and get feedback from the other commissioners as well. Talk to y'all about that. And then we would probably create another draft based on that feedback. And that's, come back to the original sponsor commissioner get their thoughts, and that would be the draft that we're publishing, probably. Like, this is our best, closest draft to what we're gonna do. You all would get copies of that, and that's when at least 14 days, begins to run in the administrative procedure part of the code. And that's when we would schedule the public hearing. It just has to be 14 days after, not on the dot 14 days. And then we would sit down, maybe we'd have members of the public here, maybe we'd have employees, maybe we wouldn't, maybe we'd have departments, maybe we have unions, maybe we have community members who are interested in the civil service rules. I don't know. But that's when you all start sort of your meeting. There's a lot of work that's gone into it at that point, but that's your open public meeting work. That's if you have to get legal advice in executive session. But mostly it's out here in the open. And Joe's right, it can take more than one meeting. Since I've been executive director, I bet we've done this 8 times with the public safety civil service rules, not in a humongous scale. That's yet to come for public safety, but on a 1Z, 2Z, 7Z rules at a time kind of situation. So we've done large and we've done small. We've never done humongous. And I don't think what we're contemplating here is I would describe it as humongous. Do you have questions on that process? It will be something that you all can totally handle. Like, you'll have lots of opportunities for question and discussion along the way. I have absolute confidence in all 3 of you that we will make it as easy for you as possible. And we want to get everybody's input and incorporated in. And on the back end, we want to make it usable for us and useful for our employees. That's the most important.
Cool. To be clear on that point as well, though, your current rules are wholly lawful.
Yeah.
They're legally sound. This is just more. They're never perfect, so this is a way to improve them and have some clarification. Because Sarah may have mentioned previously, or Andrew did, because this commission has the authority to delegate hearings to the hearing examiner. The hearing examiner's provided some input related to how to do hearings, which is definitely worth your consideration.
Yeah.
So to revise your rules to reflect, because the hearing examiner does this on a regular basis, so they have some good thoughts about how the current structure you have could be changed in some manner.
It's like improved, updated, clarified. It's still, our rules are also talking about U.S. Postal Service delivering, copies of binders and, just to bring us into the current day. But that's not the only purpose. The other purpose is, to fill in some details, describe some things more clearly where questions have arisen, and just kind of improvement. But we're not talking right now about big substantive changes. Do you have more to add?
I don't. I guess assuming this all goes smoothly, I'm looking at July, August for consideration, and in terms of whether to lead on this.
What do we think of, what can we guess on a time commitment for the commissioner who needs or sponsor for this rulemaking?
I think a couple of hours.
Yeah.
2 hours just to do the draft. Go over any questions.
Yeah, let's double it to 4 hours over the next few months outside of meetings. Anybody?
Unless either of you are chomping at the bit, I'd be happy to take the lead on that.
Yeah, that's fine, we support you. I like doing that.
Great.
But it's more. Thank you so much.
Thank you, Commissioner Warren. That would be great.
And keep in mind, at the end of the day, these are your rules, commission. You decide what's going to be. So staff will do a bunch of work and get input from various folks. But at the end of the day, in terms of offering amendments, revisions, considerations, your vote will adopt them or not. So that's why Andrew's getting involved early on and describing the process, so that there's no surprises. It's all collaborative and a way to improve the situation that you feel good about what's the work that's done.
Okay, good. Thank you so much, all 3 of you.
Thank you, Steve.
Very welcome.
Well, we're at the end of our agenda. Unless any commissioner has anything else for the good of the order, can I have a motion to adjourn?
I have nothing else. I will second the motion.
So moved?
So moved.
All in favor, say aye. Aye. Meeting is adjourned at 3:45. 37, something like that, 3:36.
Good job, Denise. My note is, wow, Denise is doing great. That's great. Thank you so much.